413.7, describe how to legally administer an oath and obtain a sworn statement. Florida statutes grant officers the authority to administer oaths while performing official duties, though it does not certify you as a notary. If a person objects to an oath due to religious or philosophical beliefs, allow them to make an affirmation instead. Legally administer it by explaining that giving false information constitutes perjury. Instruct them to raise their right hand, a standard practice though not legally required, and ask, do you swear or affirm that the statement you are about to give is true and accurate to the best of your knowledge? It's covered on page 129 to 130. 413.8, describe how to obtain a written sworn statement. Explain the reasons for the request and clear guidelines on what details to include. Property descriptions, events, persons, weapons, vehicles. Have the interviewee write clearly to the best of their recollection. If they leave out information they mentioned orally, ask them to include it. If they're non-English speaking, they may write in their preferred language for translation review. If they cannot read or write the statement in their own words without paraphrasing or summarizing. Document if someone is unable to or refuses to provide a statement. 413.9, describe how to obtain a signature on a written statement. Read the statement to verify it is complete and legible before the interviewee signs it. If you wrote it on their behalf, read it back to them, make corrections, and have them sign and date it, or make a thumb mark. A witnessing officer should also sign. If dictated, add dictated by and written by officer. If they are incapacitated and cannot sign, write the reason why. If they refuse to sign, write refuse to sign at the bottom. Covered on page 131. 413.10, describe how to obtain an electronic statement. Test equipment beforehand. Keep all interview recordings as evidence in accordance with agency policy. When starting the recording, state your name, names of others present, location, day, and date, the incident being discussed, case number and type of incident. Record the administration of the oath. If you pause the recording, document the reason for the pause, the date, time of resumption, and state that no questions were asked during the pause. At the end, state this now concludes the statement of Frank regarding the domestic violence incident, case number 0058. The time is now 22:30. 414.1, identify the difference between an interview and an interrogation. An interview is a conversation to gather facts from a person who has knowledge of an event. The situation is non-custodial, and the individual is free to leave. An interrogation involves questioning initiated by law enforcement, directly or indirectly intended to elicit an incriminating response from a suspect who has been detained and is no longer free to leave. Discussed on pages 122, 133. 414.2, explain the importance of the Miranda decision for conducting a legal interrogation. The landmark Miranda versus Arizona 1966 ruling put the burden of explaining Fifth and Sixth Amendment rights on the law enforcement officer. It requires officers to advise a suspect in custody of their constitutional rights, to remain silent and have an attorney present before questioning. If an officer fails to follow Miranda rules, any statement or admission obtained cannot be used in court. That's discussed on page 133. 414.3, describe the concept of custody in relation to the Miranda decision. Custody means a person has been deprived of freedom in a significant way. Brief investigative field contacts like Terry stops, traffic stops, and roadside DUI tests are generally not considered custody. Restricting a person's movement by handcuffing or other means so that they are not free to leave constitutes custody. Courts assess custody by looking at the facts surrounding the questioning and whether a reasonable person in those circumstances would feel at liberty to terminate the interrogation and leave. Discussed on page 134. 414.4 explain the significant case law rulings on the Miranda decision. Ramirez versus State establishes 4 criteria to determine custody: the manner the police summoned the suspect, the purpose, place, and manner of the interrogation, the extent to which the suspect is confronted with evidence of guilt, and whether they are informed they are free to leave. Rhode Island versus Ennis and Brewer v. Williams concern the definitions of direct and indirect questioning during interrogations. Quarries versus State establishes that if a suspect, Quarles versus State establishes that if a suspect reinitiates contact after invoking rights, simply reminding them of previous Miranda rights is insufficient. A completely new advisement and waiver must be conducted. That's on page 136. And then Maryland versus Schatzer rules that if a custodial suspect invokes the right to counsel, law enforcement may only reinitiate contact without counsel present if the suspect experiences a break in police custody of at least 14 days. That's also on page 136. 414.5 explain the importance of a suspect understanding their rights. You must ensure the suspect understands their rights, taking into account their age, national origin, education, mental, physical disability, the circumstances of the advising, and whether they are under the influence of an intoxicating substance. If the suspect does not understand their rights, any waiver given will not be valid, and subsequent statements will be inadmissible. Document all measures taken to ensure understanding. Page 134. 414.6 describe when and how to administer a Miranda warning to a suspect. Administer Miranda warnings only when both elements of custody and interrogation are simultaneously present. To administer them, read the rights one at a time exactly as written from an agency provided Miranda card or form to guarantee accuracy, enhance courtroom testimony, and ensure policy compliance. 414.7 describe how to respond when a suspect invokes their Miranda rights. If a suspect makes a clear, unmistakable request to invoke their rights, all questioning must cease immediately. If they invoke the right to remain silent, you may only reinitiate interrogation after a significant lapse of time. If they invoke the right to an attorney, you cannot question them unless their attorney is present or the suspect reinitiates communication. If they reinitiate contact, a completely new Miranda warning and waiver must be documented. 414.8 describe the standards for interviewing or interrogating a juvenile. The same interrogation standards apply to juveniles as adults, but a juvenile waiver is scrutinized much more closely based on age, marital status, education, intellect, and police experience. JDB versus North Carolina. Florida statutes require you to make a reasonable effort to contact parents or guardians when a juvenile is taken into custody. Document exactly what you say regarding whether they are free to leave. Interrogations must last only a reasonable length of time. You must note any pre-interrogation delays, the number of breaks, rest periods given, and adhere to agency limits on the number of times a child can be interviewed. That's discussed on page 136.